burden of proof on privileges is the defendant. Burden of proof on the prima facie case is on the plaintiff. So logically, and it's probably safer to start with, can plaintiff prove these things? Do you have volitional conduct? Go to whether, in this case, did it cause a touching? In fact, you can treat that as one element. Did the conduct cause a touching? Solve that first. If you don't have a touching, who cares about intent? So do you have conduct causing a touching? Then go, did the defendant in that conduct intend to cause the touching? That'll give you the intentional touching needed. Then you've got to see whether it was harmful or offensive. I may have intended a touching, turns out it didn't cause you any actual physical harm, and it wasn't offensive. You have to prove harmful or offensive. Can you skip these things when I give you an obvious fact pattern? So-and-so jumped at the person, stuck the knife in his chest, blood spurted out. To be thorough, you do what you do at trial. You use each fact to make sure you've got conduct causing a touching, harmful or offensive touching. So you'd say, obviously here, we've got conduct that causes a touching because the facts said the knife entered the chest. It's harmful because the facts show that the knife entered the chest, blood came out. It was intended because from the fact stating he jumped at the person and stuck the knife in him, obviously it was his desire or purpose to do so. That's all you got to say. But notice you hit each of the elements. So now you've got conduct intended to cause and causing a harmful or offensive touching. Next you go to without consent. Usually you will have already proven there's no consent by proving the rest of it. Absent any other facts where someone sticks a knife in your chest and blood spurts out, you weren't consenting to that touching. We're inferring the lack of consent from the other facts you've already shown. So where it's obvious, you just say, there aren't any facts indicating consent. But you stop and pause at consent because there may be some issues that we'll get into a little later. With harmful or offensive, those are just, it's a requirement, it's the law. You have to tell me that's the law. You can't just start arguing it's harmful without telling me harm was required by the law. It's a law exam. So you've shown me that you know what has to be proved, and then you're going through the elements. What trouble can you get into with harmful or offensive? Generally, only on offensive. Offensiveness can become arguable. The facts are either going to show physical harm or they're not. Don't assume there's physical harm, though. I think even in real life, if it says that someone threw something at someone else and it touched them, can we infer from that it's harmful? Maybe we can, but it's safer to say there are no facts indicating whether the touching actually brought about any harm. Then move to offensive. Once you're at offensive, you're back to stating law, because there's law specifically about when touchings are offensive. You've got to state the reasonable person rule. Touching is offensive only if a reasonable person in those circumstances would consider it offensive. That's how you prove that touching was offensive, if not harmful. Is that any reasonable person in these circumstances would consider that offensive? It's usually not arguable. To make it clear for yourself, remember, there's no consent to this touching. So the issue is always, is this unconsented touching, would it be offensive to a reasonable person? If so, you've proven offensive touching. If it's arguable, you can argue, hey, reasonable people under these circumstances would not consider it offensive, then make the argument. Try to use some facts why. We saw that a touching on, as an example, there's a touching while riding on the subway. The subway comes to a sudden stop. You're standing, you're not sitting in one of the chairs. You're going to lurch forward, you're going to fall. Let's say you're elderly and you're delicate. You don't want to fall. You grab someone's waist. Turns out to be a young woman's waist. She's highly offended. She sues you for battery. Your touching of her didn't cause her any harm. So the issue is going to be, was the touching offensive? Would a reasonable person under those circumstances consider the touching offensive? That's the law. Then you apply it to the facts. Plaintiff would argue that grabbing people without their consent in public around their waist is clearly an offensive touching. Defendant would argue, however, no, under these circumstances, no reasonable person would think that's offensive because it would just save someone from possibly serious harm. Then you get into the facts of where there are things to hang on to. And if you can hang on to that stuff safely, it is offensive to start grabbing waste as a way of saving yourself when you haven't even grabbed on and held things that are provided for you. So you argue it back and forth. So under the element of harmful or offensive, you should never lose any points, unless the issue is offensiveness, and you never tell me the law about how we decide offensive. Or if you jump into arguing, she was highly offended and therefore it's an offensive touching. You've got to show she was offended, but then you got to show her being offended was reasonable. You can't keep it subjective. If in fact there's no harm and personally they're not offended, one, they won't sue you, but two, if they admit that on the stand, then there is no offensive touching. So for offensive touching, you got to show the person will claim the touching was offensive, and a reasonable person under those circumstances would consider it offensive. Then you've got it. With regard to does the conduct cause a touching, the only issue you could get on that, I don't remember students screwing this up, is what if they're not actually touching you? They've touched your clothing. They've touched something in your hand. They've touched the bike you're sitting on. They've touched the car you're sitting on. They touched the building you're sitting in. At what point does that not become a touching? Obviously, if they shove you, they can't say there's no touching because all they touched was your shirt. Obviously, the touching of the shirt caused the touching of you anyway. But anything closely or intimately connected with your body will work as part of a touching. That's the snatch the plate out of the guy's hand case that we saw. Touching the plate was a touching of his body. So anything closely associated with the body or closely connected to the body. If you're sitting in a car and they kick the tires, no court's going to say that's a touching of you, unless you're actually moving the car. That's now moving your body. That is causing a touching. On a bicycle, it'd be the same thing. If I kick the bike and you don't feel it, I haven't touched you. If I kick the bike so hard that it moves you or you feel it, now I've caused the touching of you. For things other than that that are intimately associated, I mean things in people's hands or that they're wearing or the rest of it. You don't have any real damages issue with a battery. You get all damages caused by the battery. So if I shove you and it really hurts, you'll get the pain and suffering of how it really hurts. If it also causes you to fall down and break your leg, you'll get that. If in getting medical treatment, it's a painful medical treatment, you'll get compensation for that. You get all the harms that come from my unconsented touching of you. You're not really tested on damages of battery in this course, so you don't need to worry about that. Okay, assault. Again, you have to know the definition. We've seen it repeatedly. I think the safest way of saying it with any of these torts is you use the magic phrase, conduct intended to cause and causing. That solves a lot of problems. Conduct intended to cause and causing reasonable apprehension of an imminent battery without consent and without privilege. That gives you your checklist of things you got to analyze whether or not on the given facts plaintiff can prove what plaintiff has to prove. When you get down to privilege, you look at the given facts and see whether the defendant can prove a privilege. Where do students mess up on assault? By forgetting about it because there's a battery. Generally speaking, you ask yourself, do I need to go through assault and battery in a fact pattern? If there's some time between defendant's conduct and the touching, the battery, then you got an issue about assault. If it's only a second, I'm rushing at you from 2 feet away and I hit you within a half a second, no one's going to sue for assault there. You don't have to analyze it. Why aren't they? You don't have enough damage to make it worth it. But if it's from a number of feet away in a fact pattern, someone is screaming and rushing at someone, that's the key, that you got an assault. Whether they succeed with the battery is irrelevant. They've assaulted you already. So for facts where there's just a touching and it happens swiftly and not at a distance, you don't have to get into assault. Just do the battery thing. There's no damages from the assault. Once you get time and distance between the conduct and the battery, you may or may not have an assault. In analyzing assault, do you have conduct? You need the volitional conduct. Start with, did you have conduct causing apprehension? don't treat apprehension alone. It's apprehension of a very particular thing. You got to be apprehending an